In fact, that's one of the things that I'd like to do now is address a couple questions that came in after last week's show. One of the big things is people called in and asked the question, do I have to have a foreclosure judgment before you can wrap a deficiency judgment into a bankruptcy? The simple answer to that is no. Your liability for a bankruptcy note does not have to have a deficiency judgment. The deficiency judgment is a liability on the note. If that note gets discharged in bankruptcy, they can't come back after you for a deficiency judgment. This has become a very, very hot topic recently as Freddie and Fannie Mae, they came out with a press release in June saying they were going to pursue deficiency judgments against homeowners. Of course, this begs the question, why now? Well, part of the reason why, in our opinion, is that the foreclosures have started to slow down a little bit. So now the foreclosure lawyers are starting to go back and revisit those files. They're starting to go back and look at the cases where maybe somebody walked away and didn't answer the foreclosure, or maybe somebody just didn't want to go through the house at all. So now they're going back and looking at those to see if they can get a deficiency judgment. Unfortunately, here in Southwest Florida, most of our houses are worth less than what was owed on the mortgage at the time. Then you go in and add the costs and the fees that the attorneys for the foreclosure are adding on, and most people face a deficiency judgment. Now, if a deficiency judgment is something relatively new, 3 or 4 years ago during our booming housing market, we didn't have deficiency judgments because the properties were worth more than what's owed. So there's been a lot of questions that have come up about that. One of the first questions I get asked is, how long does somebody have to come after a deficiency judgment? Well, there's 2 ways that a deficiency judgment can be pursued. One is part of the original foreclosure case, where they come back into the foreclosure case and ask the same judge in the same case to reopen it and issue a deficiency judgment. Well, the time limit for them to do that, according to current case law, is 1 year. So if it's been more than a year since you got your foreclosure judgment and it was sold, then they can't come back in that same case. What they're going to have to do is they're going to have to file a new action. So it'll be a new lawsuit. You'll have to be served again in order for them to try to enforce a deficiency. Now, the important thing to remember is if you get served with a lawsuit and it relates to a property, don't think, oh, well, that property's gone. It got foreclosed on 2 years ago. I don't have to worry about it. That's not true. The deficiency judgment is an attempt to collect a monetary judgment against you. As with all judgments in the state of Florida, if that judgment's recorded, it's valid for 9 years, and it can be re-recorded for an additional 9 years. So don't ignore any papers you get from the court. Similarly, if it hasn't been a full year since your foreclosure sale, you need to make sure that you check anything that comes in the mail. You may just get a motion for the court to enter a deficiency judgment. That motion is not going to be served to you like a typical lawsuit, like the original lawsuit was brought to your door. It's probably just going to come by mail. The important thing to remember about that is even though somebody files a motion for a deficiency, it doesn't mean that they have to have it granted. You have legal defenses. You can challenge their valuations of the property, the times. There's equitable arguments. Perhaps you tried to do everything you could. Perhaps you tried to do a short sale. You tried to do a deed in lieu of foreclosure. You offered them a modification and they wouldn't accept it. Those may all be mitigating factors that reduce your liability to a deficiency judgment. So the most important thing, as it is with any lawsuit that you can receive, is that within the time allotted for a response, that you seek the advice of a competent legal attorney. And make sure that it's not just somebody that said, oh, I walked away from my house, you don't have to worry about it. 2 years ago, that's what was happening, as these lenders were so overwhelmed with foreclosure cases. However, now, as they've taken their time and gotten rid of some of the backlog, now they're looking back at some of those cases and seeing if they can try to collect money from the consumer. Unfortunately, it's just another attempt by the banks to collect more money from those people that have already suffered a big hardship.